Good evening, everyone, and welcome to the Catholic University of America, Columbus School of Law. My name is Verrill Miles, and I'm delighted that you're all joining us for what is a very, very special event today. We are today starting a new tradition here. Today will be the first William Callahan Robinson inaugural lecture. And of course, William Callahan Robinson is very responsible for our being here today as the founding dean of our law school. And we're very proud of his legacy, and we're very excited to be able to learn a great deal about what he has done, not only in terms of founding this law school in legal education, in terms of the work that he did in legal education many, many, many years ago, but also his role in the area of patent law, which is very important as we are continuing to develop what I believe is a very strong and exciting intellectual property program here at the Catholic University of America. I am going to get out of the way so that Judge Schall can come forward and introduce our speaker. He is the senior circuit judge for the United States Court of Appeals for the Federal Circuit, and we are delighted that he's able to come here today and help us celebrate this inaugural lecture. Judge Schall?
Dean Miles, thank you very much for what I'll call that kind introduction of the introducer. First, let me say how delighted I am to be here for the first Dean William C. Robinson lecture. I think every fan of patent law knows Robinson on Patents, which is the celebrated treatise from the 1900s. But as Dean Robinson alluded to, Dean Miles alluded to, beyond our time, not everyone knows that Dean Robinson did his work right here at Catholic University Law School. Professor Robinson taught at the Yale Law School from 1869 to 1895 when he came to Catholic, where he stayed until his death. I think that given the awesome stature that Robinson enjoys in the law of patents, I can imagine that it must be more than a little daunting to be called upon to give the first Robinson lecture. But it is a great honor to be asked to give the first lecture, and I am pleased to have the opportunity to introduce Professor Jeffrey Lefston, who will deliver the inaugural lecture. Professor Lefston's topic this evening, quite fittingly, I think, is William Callahan Robinson and the Essence of Patent Law. Professor Lefston will explore Robinson's life at the law and suggest that Robinson still has much really to teach us as we grapple in this modern world with the peripheral claiming system we inherited from Robinson's time. Indeed, Robinson, if you will, was on the watch, so to speak, when peripheral claiming produced the sea change in claim drafting that occurred in the last quarter of the 19th century. Now, Professor Lefston earned his Bachelor of Science degree at Brown University, his PhD in biochemistry from the University of California, San Francisco, and his JD from Stanford Law School. After clerking on the Federal Circuit for Judge Raymond C. Clevenger, Professor Lefston began his teaching career at Hastings Law School in 2003. He teaches intellectual property law with a focus on patents, and also he teaches contracts. He has lectured and written broadly. His work covers both intellectual property law and the complex sciences of biotechnology, And I think that two of his recent writings might be of particular interest. At least I was struck by them when I was informed of them. In an article entitled the Constitution of Patent Law, the Court of Customs and Patent Appeals, and the shape of the Federal Circuit's jurisprudence, Professor Lefston suggests that what has been termed heavily criticized aspects of the Federal Circuit's patent jurisprudence derive from one of its predecessor courts, the Court of Customs and Patent Appeals. And he notes that the CCPA's jurisprudence was uniquely shaped by its exclusive focus on patentability. And when, at its founding, the Federal Circuit, as we did, adopted the CCPA's precedent, it effectively, if you will, jettisoned or cast aside decades of patent jurisprudence from the regional circuits, jurisprudence that in fact was informed by the circuit's perspective of patent enforcement rather than patentability. And in another recent article, The Formal Structure of Patent Law and the Limits of Enablement, Professor Lefston argues that a conceptually ordered system of patent law founded on the peripheral claim requires disclosure doctrines beyond just enablement. He suggests that written description, if viewed as a doctrine of definition, may serve that role. Now, Professor Lefston does not limit his energies to formal academic writings, however. He is a regular contributor to patent law blogs and an active participant in legal conferences. Indeed, just this past December, he was the keynote speaker at a major intellectual property law conference in China. Just one final note. Judge Clevenger, for whom, as I noted, Professor Lefston clerked, unavoidably could not be here this evening. He wants to be on the record, however, with a few words, and now I'm quoting. Jeff Lefston is one of the finest law clerks ever to serve the court. His intellectual insights, his intellectual honesty, and his humane respect for the legal process marked him from the start as a future leader. It is indeed an honor to say that I worked with him and a sweet pleasure to see him grow into great stature in his profession. And if I might, I would just like to add a little tiny postscript or PS to that, because during the period of Professor Lefston's clerkship with Judge Clevenger and I happened to be members of a panel that had the task of deciding the merits of a very difficult biotechnology patent case. And in that setting, one of my clerks and I had occasion to work closely with Professor Lefston. Not only were his technical contributions and his legal perspectives invaluable, but it was truly a pleasure to have him as a partner in the deliberative process. And without more, I present Professor Lefston.
Well, thank you, Judge Schall, for that very, very kind introduction. And thank you very much to the Catholic University for inviting me here to present the inaugural Dean Robinson Lecture. As Judge Schall said, it is actually a little daunting, in a way, to be responsible in some sense for Dean Robinson's legacy, because as I've come to examine his work, much of which has been forgotten over the years, it's really been my first experience of reaching back and encountering such a prodigious mind as Robinson's. And so I do feel great responsibility in trying to explain his legacy today. So thank you very much for inviting me. I'd also like to thank the archivists here at Catholic University, who were very helpful to me when I came to look through Robinson's papers that are stored here. Now, as a patent law scholar, I occasionally get blank looks when I explain that I am studying a 19th century treatise writer. And I get even blanker looks when I explain that central to that study are the metaphysics of the medieval scholastics. My hope today is to show you why those two subjects, Dean Robinson's legacy and, in fact, his medieval scholastic philosophy, should be important to anyone with an interest in the law of patents. I'd like to start first with how I came to be interested in Robinson. It was when I was writing about patent law's disclosure requirements and some of the work that Judge Schall was describing. I was curious about how 19th century patent treatise writers dealt with the subject, because as Judge Schall mentioned, patent law was undergoing a fundamental change at the time, from a system in which a patentee's rights were defined by what he described in his patent application, and courts really just asked the question of whether the accused infringer was doing something sufficiently similar to what the patentee had described. In the 19th century, that system changed to one where the patentee's rights were defined not by the description or what the patentee invented, but by something known as the claim, which precisely defined the boundaries of the patentee's rights. Now, I was interested in how contemporary writers treated the disclosure doctrines during this time of change. So I went down to the library, found Robinson's 3-volume treatise there, and I think, like anyone who has seriously examined it, was immediately struck by how sophisticated and comprehensive the treatise was. It was also clear to me in reading Robinson's work that there was a distinct philosophical system behind the work, although I didn't know at that time what that system was. So I wanted to answer some of the following questions. Who was Robinson? Why did he produce a treatise on patent law? And what was the real significance of his work in patent law to the American legal system? And what philosophical system was it that was underlying Robinson's system of patent law? So I'll begin by giving you some basic biographical information about Robinson. I'll then talk about Robinson's significance in American patent law. And then I'll talk about some research that I've done that explains how Robinson came to the Catholic Church, and then how Robinson came to patent law. Then I'd like to examine the interrelationship of those two questions and hopefully show you how Robinson's Catholic philosophy was deeply ingrained and deeply shaped his system of patent law. And finally, I'll suggest some ways in which re-examination of Robinson's work may help us with some of the difficulties that we encounter in the modern patent law system. So, Robinson was born in Norwich, Connecticut in 1834. He was ordained as a priest in the Episcopal Church in 1859. And he was rector of St. Luke's in Pennsylvania for 3 years. Now, in 1863, Robinson converted to Catholicism, about which I'll have much more to say later. At this time, he also takes up the study of law. In 1869, Robinson became instructor and professor at Yale University. Now, at this point in time, Yale University's law school was on the verge of collapse. Its last professor had died, and the prospects for the law school were quite dim. At that time, however, 4 New Haven lawyers took up the challenge of adopting Yale's law school, and they became the entire faculty of Yale's law school. These were Johnson Platt, Francis Wayland, Simeon Baldwin, later governor, I think, of Massachusetts, of Connecticut, and William Robinson. Robinson, as the most senior, served as the acting dean of the Yale Law School for several years until Francis Wayland replaced him. Robinson was at Yale until 1895, produced much of his major work there. And Bishop Keene, the founder of this school, asked Robinson to take charge of organizing the School of Social Sciences here at CUA in 1891. And in 1895, Robinson came here permanently to Catholic, not only as the first dean of the law school, but as the director of the School of Social Sciences. And he remained here in Washington until his death in 1911. So some of Robinson's major works were his textbook, Elementary Law, which really became the elementary casebook for much of American legal education, more theoretical work called The Elements of American Jurisprudence, a work on oratory called Forensic Oratory, which is still studied today, and his masterwork, The Law of Patents for Useful Inventions, which he published in 1890. Now let me try to assess the significance of Robinson's work for American patent law. His treatise is widely recognized as the most influential work on American patent law ever written, and was described as the Bible of patent law for generations of patent lawyers. Our modern treatise writer, Donald Chisholm, calls Robinson one of the 3 most important figures in the history of American patent law, along with Justice Story and Judge Learned Hand. Now, it's difficult, standing from this perspective, to really address Robinson's, or really assess Robinson's influence. Since I had a background in some empirical work, I thought it would be interesting to actually examine, if I could, the impact of Robinson's treatise on courts in the late 19th and early 20th centuries. And so what I show here is a very crude textual study assessing how often patent opinions in the federal courts cited various treatise authors. And what you can see from the chart is that around 1890, the primary treatises available were Curtis's and Walker's. Robinson's treatise is published in 1890 and immediately becomes the most dominant treatise in American patent law, at one point being cited by nearly 1 out of every 10 patent cases. Now, Robinson never returned to patent law. He never published another edition of the Law of Patents nor updated the work. So in time, his treatise became superseded, at least in citation, by more recent editions of the other leading American treatise, Walker. But Robinson was still being cited almost as much as Walker some 25 years after the treatise was published. And I would be very happy if any of my work was still being cited 25 years after it was published, but I have no such ambitions. I believe that Robinson's influence on patent law, though, extended beyond the United States, because Robinson taught a number of students from Japan when he was at Yale and when he was here at Catholic. You may know that in Japan, the post-Meiji government was very interested in the patent system of the United States and initially modeled its patent system after our own. Robinson's obituary states that one of his students revised the patent laws of Japan and was honored by the Japanese emperor for doing so. I've been unable to verify those claims. However, in looking through the archives here at Catholic, I did discover that one of Robinson's students, a man named Kinosuke Tsujita, eventually rose to become director of the Imperial Patent Bureau in Japan. And so it may be quite likely that Tsujita had significant influence on Japanese patent law. Now, why was Robinson's work so influential? It is difficult to convey in a format like this the power of Robinson's thinking. His work was, I think, so influential because it was the most systematic and comprehensive treatment of patent law that had ever been attempted up to that point, and probably none so comprehensive ever since. Moreover, and probably more important, Robinson was really the first theoretical writer on patent law from a legal perspective. Other writers of the time, if you look at their treatises on patent law, tend to simply be a collection of cases. Robinson was really the first legal writer to delve deeply into the theory of patent law. And what I'd like to do is give you some examples of his thinking, which foreshadow many academic treatments of patent academics today. Now, just last week, I went to a talk by one of America's leading patent law scholars entitled The Myth of the Sole Inventor, who was arguing that we think about patents in the wrong way because patents are rarely, or inventions are rarely the work of sole inventors. Rather, it's typical that many people are working on the invention at the same time. And the real value contributed by the one who invents first is not that he gives us something that we would have never had, but rather that he gives us an invention earlier rather than later. So I informed Professor Lemley that, in fact, his article had been anticipated by some 120 years by Robinson's treatise, because Robinson clearly recognized, as you see from this excerpt that I have from his treatise, that very frequently inventions are simultaneously invented, and that the value contributed by the inventor is not that he was the only person who could have gave us the invention, but that he gave us the invention earlier than we would have had absent his efforts. For those of you who are familiar with the theory of patent law, you know that one of the most interesting and controversial theories of patent law in the 20th century has been Ed Kitch's prospect theory, which holds that the patent system not only incentivizes the creation of new inventions, but provides critical incentives and security for inventors to develop those inventions into practical form and then to subsequently improve on those inventions. This, too, in its essence, is found in Robinson's work. Robinson recognized that there's a vast gulf between the mental conception of the invention and the reduction of that invention to practical form, and that the patent system provided not only the incentive to create the invention, but the incentive to put it into practical form and the incentive to improve upon the invention. Another strand of academic commentary in patent law today is the concern, however, that patent law may actually retard the progress of science by restricting research or restricting improvements on patented inventions, since such improvements or directions of research will be subject to the patentee's rights. Indeed, Robinson recognized this as well in his criticisms of the patent system, recognized that the patent system blocks off areas of research that would otherwise be free to the public, and furthermore, that the inventor may not be the best person himself to improve upon or exploit the invention, and that in cases where the inventor is not, the inventor's skill and enterprise, in Robinson's words, are not optimal to commercialize the invention, the patent system leads to a slowdown rather than an acceleration of technology. Robinson's insights, however, extended beyond the economic treatment of patent law. As a practicing lawyer, he was interested in the practical aspects of patent adjudication as well. So one of the cornerstones of patent law today is that the process of claim construction, by which we interpret the boundaries of the patent, is decided by judges, not by juries, and we treat it as a question of law. This was decided by the Supreme Court in Markman and remains somewhat controversial even today. But one of the advantages cited by the Supreme Court and other people who argue in favor of treating this interpretive process as a question of law is that this leads to uniformity of interpretation, that once a question of interpretation is treated as a patent of law and subject to a central appellate court, then the patent receives a uniform construction in all suits that the patentee might assert it, whereas if we left it to juries, it might be construed differently in different cases. Robinson recognized this advantage as well, although in his case, of course, the uniform appellate review would be obtained by the Supreme Court and not today's Federal Circuit. So I hope that these examples give you some example of the incredible sophistication and complexity of Robinson's thought. I think Robinson had the disadvantage to be a true legal academic before there was such a thing as legal academia, that is, a literature devoted to theoretical study of the law. Robinson probably also had the disadvantage of being able to say in a paragraph what myself and my academic colleagues take 100 to 200 pages to do. All right. Well, I'd like to turn, most of what I've told you now is known if in some of the histories that have been written about Catholic or about Robinson himself. Now I'd like to tell you about some things that I've discovered about Robinson through my own research. The first is how Robinson came to Catholicism. Now, as I said before, Robinson began as an Episcopal priest. And for a man like Robinson, conversion to Catholicism in the late 19th century entailed a loss of social standing. And for married priests like Robinson, it generally entailed a loss of income as well, since they were generally unable to serve in the clergy. Nonetheless, Robinson was one of a stream of intellectuals, both here and in England, who converted from Episcopalianism to the Catholic Church in the mid-19th century. Robinson was converted by the Paulist Fathers, and it's clear from Robinson's writings that he shared many of the ideas of the Paulist's founder, Isaac Hecker. Now, this philosophy later turned Americanism, and the controversies that it engendered are intimately tied up not only with that period of time, but also with the founding of this university. This philosophy of American Catholicism, or Americanism, was inspired by the Transcendentalists and by evolutionary thought. It prized intellectual freedom and free will, and it emphasized what it viewed as uniquely American values: freedom of speech, inclusiveness, democracy, and separation of the church and state. As I said, it's quite clear from Robinson's writings that it is very firmly in this mode of early 19th century or late 19th century American Catholic thinking. I discovered, however, Robinson's personal views in an article he wrote in 1868 when he was associate editor of the Paulist magazine, The Catholic World, when he describes the challenges faced by the American Episcopal Church in the years before the Civil War. In the period immediately before the Civil War, the Episcopal Church was challenged from within its hierarchy by dissidents who viewed the Episcopal Church as too socially narrow, as too geographically limited, and its liturgy too austere for the task of evangelizing an American society that was ever-growing and ever-growing more diverse. Within the Episcopal Church, this movement was rejected by the Church in favor of a more determined expression of Anglican distinctiveness. And this failure of reform seems to have been instrumental in Robinson's decision to leave the Episcopal Church. For Robinson, a church for America had to be adapted, in his words, to men of every nation, color, class, or tongue. And moreover, as Robinson put it, in a democracy, the popular vote is a tribunal from which there can be no appeal. And in Robinson's view, to provide a firm moral compass for a free people, a church for America had to be one that was immovable in her doctrines and spiritual teachings, and yet flexible in its methods. And Robinson apparently saw in the Catholic Church that combination of immutable principles and flexible methods that would uniquely serve the task of evangelizing the American people. Now, how did Robinson come to patent law? Well, there's no apparent connection or interest in patent law in Robinson's life prior to his treatise. And in his treatise, Robinson says that he turned to patent law out of a belief that the law had reached a stage suitable for scientific study. I think, however, there's significantly more to the story than Robinson lets on. So let me describe for you the context of patent law in the late 19th century. Patent law in the late 19th century needed friends. Like our own time, the patent system was a very important part of American law, and yet was subject to tremendous criticism. Internationally, there were movements in some of the major European countries to abolish the patent system, and these movements were only barely beaten back in the mid to late 19th century. In the United States, of course, we had the suspicion and hostility of monopolies that ultimately led to the Sherman Antitrust Act. Moreover, the explosion of the patent system after the Civil War created a great deal of controversy in the United States. And the rhetoric, in fact, was almost precisely identical to some of the rhetoric we hear today. Opponents of the patent system argued that the Patent Office was being overwhelmed by the flood of applications it received, and that there were too many bad patents out there that were being asserted against innocent infringers by patent trolls. The one difference in the rhetoric is in the 1870s and 1880s, they didn't use the word patent troll. They were described as patent sharks instead. Aside from that, however, you could transplant the debates into today's newspapers. In particular, some of the parties that were hostile to the patent system were the Grangers, the Western agricultural interests, who tended to be incensed by the attempted enforcement of a patent on a method of drilling wells. And furthermore, the railroads. The railroads were the Microsofts of their day. They had very large and complex operations that were subject to numerous hundreds or even thousands of patents. And like a typical technology company today, they may have large sunk costs. And in an interesting political dynamic, the railroads essentially bankrolled the Grangers to fight for limitations of the patent system in Congress. So the political fight was the poor farmers who were being oppressed by the patent system, and yet the money and the impulse for these attempts came from the railroads. And in fact, a bill to severely limit damages and other remedies of the patent system almost passed Congress in 1884. So patent law was needed friends at about the time Robinson started writing. However, I think there's an additional connection in that Robinson, of course, was from New England and specifically Connecticut. The conflict over patents was part of a larger economic conflict between the industrialized Northeast and the agricultural West, with the Northeast being much more pro-patent. And indeed, Connecticut had the highest per capita number of patentees of any state in the Union. Moreover, Robinson probably had close contact with Senator Orville Platt, who was described as the savior of the patent system for his efforts to defeat the Patent Bill of 1884. Senator Platt was the senator from Connecticut. He had received an LLD at Yale in 1887, and he cites some of Robinson's work in speeches. So it's probable that Robinson had close contact with Senator Platt. I found, however, though, that Robinson had an even more personal connection with the patent system. That when I was examining his papers here in the archives, I found an actual patent. And this patent was issued in 1880 to one John A. Robinson and Robert H. Dimmock. Now, John Robinson was William's brother, and Dimmock was John's brother-in-law. John was at Yale as well and followed William to become an assistant professor here at Catholic University. And in fact, in 1882, John Robinson assigns his interest in this patent to William Robinson and one of his other brothers for $10. And 1882 is precisely the time, according to Robinson's own account, that he begins to study the patent system. So I think it's very likely that besides the national interest in the patent system and his regional connection to New England, having a brother who was an inventor and a patentee was probably the factor that sparked Robinson's interest in the patent system. Now let me turn to Robinson's system of thought. Running through all of Robinson's work, whether in patent law or not, is the unshakable conviction that law can be studied as a formal science. Law, in Robinson's words, was a body of fundamental principles and deductions drawn therefrom in reference to the right ordering of social conduct. And for many 19th century thinkers, the ideal model of law was Euclidean geometry, a system whose every precept could be deduced from a small number of fundamental axioms. Now, we often associate this notion of law as a science with Christopher Columbus Langdell, who was at Harvard in the 1870s. And his system of law, which came to be known as classical legal orthodoxy, was heavily criticized by the legal realists as being overly formalist, abstract, and rigid. It's critical to realize, however, that Robinson's legal science was not Langdell's legal science. There was another tradition of legal science in the United States from before the Civil War. And this tradition also viewed law as a science, but it viewed law based on fundamental principles that originated both in the divine ordering of the world and in history, in previous social conditions. In contrast, Langdell embraced a more positivist legal science in which law was not an expression of transcendental principles, but of more narrow and technical principles that courts used to decide real cases. And for decades after Langdell's innovations at Harvard, Yale in particular remained the bastion of alternative legal science, a science of law, but one based on transcendental principles and not the mere command of a sovereign. And Robinson, like all the Yale faculty until the 20th century, firmly maintained this vision of transcendental law, which as a matter of legal pedagogy entailed rejection of Langdell's case methods. This conception of legal science was also suspicious of legislative enactments because the members of the legislature were not likely to have undertaken law as a reasoned conclusion drawn from eternal principles. It would be mistaken, however, to view Robinson's legal science as abstract or rigid or one of pure logic, because Robinson firmly believed that the eternal principles behind the law could be discovered by such sciences as sociology and economics. And indeed, he came here to Catholic not to merely establish a department of law, but to establish a school of social sciences. Moreover, while the work of judges or scholars might demand the mastery of law as a science of transcendental principles, in Robinson's view, the mastery of law as an art required mastery of the nitty-gritties of legal practice. And Robinson was an advocate of what today we would call clinical legal education. It's interesting to note as well, Robinson had quite progressive views for his time. When coming here to found the law school, he strongly believed that admission to the law school should not be determined on the basis of color or of sex. But, however, the most distinctive aspect of Robinson's legal thinking is not his view of law as a science, but his embrace of the philosophy of the great Catholic scholar Thomas Aquinas. And this is an excerpt from Robinson's own description of himself from the class of Dartmouth, the Dartmouth class of 1854 history. And so ask yourself how you might describe yourself in your college yearbook. Robinson describes himself in philosophy a follower of St. Thomas Aquinas, subject to such modifications as the later progress of physical science required. And this commitment to Thomism is evident throughout all of Robinson's thinking. Now, as someone with no training in philosophy, I confess I feel a little bit silly coming here of all places and trying to say something intelligent about Thomas Aquinas. So I'll ask for your forbearance and give you my brief summary of significant aspects of Thomistic philosophy that I think are important for Robinson's thought. Of course, Aquinas was committed to natural law, and that forms the basis of Aquinas' system of law. In addition, Aquinas shared the scholastic commitment to what we'll call moderate realism, which is accepting, I might summarize as accepting the reality of the tangible world versus a sort of Platonic view that the tangible world is an illusion, but nonetheless not denying the existence of universal concepts. Moreover, being a Thomist means a view to an essentially Aristotelian metaphysics. Aquinas is often considered responsible for the elevation of Aristotle as the preeminent philosopher in the eyes of medieval philosophers. And of course, some of Aquinas' most notable philosophical and theological developments come from his transformations and refinements of Aristotelian concept. To be an Aristotelian is to focus on causes in the Aristotelian theory and essences. And this focus is central to much of Aquinas' theological and philosophical work. In addition, a key feature of Aquinas' theory of cognition was the ability of the intellect to abstract the essence from individual sense perception. And in part, according to Aquinas, to understand a thing is to understand its essence, which is those properties without which it would cease to be that which it is. Now, how are these aspects of Thomist philosophy embodied in Robinson's system of patent law? Now, of course, no doubt some of Robinson's views on legal science and the importance of transcendental principles derived from his commitment to natural law. I wouldn't go so far as to say that Robinson's model of patent law is a natural law model. It is rather a contractual model. Importantly, in Robinson's view, though, the obligation of society to protect the inventor was inherent once the inventor had fulfilled his obligations by disclosing the nature of his invention. So in Robinson's view, the protections offered by the patent system were necessary to satisfy a contract between the inventor and society, and neither courts nor legislatures, in Robinson's view, had the power to detract from those rights. Now, I've said that to be a Thomist is to be a moderate realism. This is manifest in Robinson's thinking in his firm commitment to the existence of the invention as a physical thing beyond the law. Robinson tells us, in deciding what is the essence of an invention, that the invention is a physical operation or instrument, and its essential characteristics are determined by the laws of nature. No legislation, no human act, in Robinson's view, can increase, modify, or diminish its necessary attributes. This seems allied with Robinson's rejection of Langdellian positive law, his belief that the invention exists outside the law, and it is the legal system which must conform itself to the reality of the actual invention, rather than the invention conforming itself to the needs of the legal system. Next, causation. The focus on causation was responsible for one of Robinson's most significant contributions to the law of patents. Causation, of course, was fundamental to Aquinas' system of thought. And Robinson lets us know the significance of causation in the quote he puts at the beginning of his work on patents, which roughly translated is, "Happy is he who knows the cause of things." Well, how does this play into Robinson's view of patent law? Courts and commentators at this time have struggled mightily to try to come up with a definition of what an invention was. In Robinson's view, one had to ask the question of what an invention was by asking what was the cause of the invention. And for Robinson, the cause of the invention was the inventive act. And he tells us that no apprehension of an effect can be more perfect than that which is obtained through the examination of its cause, which seems quite clearly a paraphrase of Aquinas from the Summa Theologica. So for Robinson, the emphasis on causation leads to the definition of the invention as the product of the inventive act. What is the inventive act? For Robinson, it's two things. Its conception, the formation of the mental idea of the invention, and reduction to practice, the construction of a physical prototype of the invention. Robinson is in large part responsible for our current view that the conception of the invention, the creation of the mental idea of the invention, is the date, at least under current law, from which invention should be defined. In our current system, generally speaking, one who conceives of the invention first is the first and true inventor. And although Robinson, I would say, is not the only person to be thinking along these lines in the 1890s, that doctrine is incorporated into American law through the pivotal case of Mergenthaler versus Scudder in 1897, which is still cited for the doctrine of conception. And as you can see, Mergenthaler itself takes its formulation of the notion of conception from Robinson's treatise. So Robinson's focus on causation is the reason that he identifies conception as the key to the inventive act. For Robinson, however, though, conception is not sufficient to complete the inventive act. In order to complete the inventive act, you have to reduce the invention to practice, which is to actually bring it into being. Robinson says of why the invention must be physically constructed in order for the inventive act to be complete. He tells us in his treatise, its possibility must become actuality. This is purely Aristotle and Aquinas, who emphasized theories of potentiality and actuality as characters of objects. So it's clear that Robinson's major contribution, his definition of what it is to invent, derives in very large part from his Thomist inclination. Now, for Robinson, what is the inventive act? What is, for Robinson, the essence of invention? For Robinson, invention included the idea of an end and the idea of a means. Now, for Robinson, the end was merely the satisfaction of a public want and was not something that the inventor created. Therefore, for Robinson, the inventive act was the generation of the idea of means. For Robinson, the essence of invention was the inventor's idea of means. What is the idea of means? In Robinson's theory, the idea of means is a combination of a force, an object, and a mode of application to force. The inventor creates none of these, but discovers a new union between these forces. pre-existing factors. Now, the idea of means is the cornerstone of Robinson's theory of patent law. What are its implications? Well, for Robinson, the test of identity between two inventions is identity in the idea of means. Now, it's important to realize that at this time, identity takes on two distinct but equivalent roles. Identity is the test for whether an invention is novel. So for Robinson, an invention is novel if the idea of means embodied in the invention has not been known before. Moreover, the test of identity is exactly the same test for infringement. So for Robinson, and for many courts at the time, an accused device infringes if it embodies the same idea of means as the inventor. And so you notice in Robinson's discussion of the idea of means, he says the intrinsic character of each invention, stripped of all adventitious attributes, must be made apparent to the mental vision. Again, this is pure Aquinas. This is reference to Aquinas' theory of cognition, in which the intellect strips away the particulars that are associated with sense impression and abstracts the essence of an object or the class to which it belongs. So for Robinson, mere variations in form are unimportant. The question, both for novelty and infringement, is whether two things embody the same essence, the same idea of means. Now, how does this theory that the idea of means is the essence of the invention square with the system of claiming? As Judge Schall described, by this point in patent law, we had evolved claims. And as I mentioned, the inventor's rights were defined not by the thing which he invented or described, but by the claims. And Robinson, as you can see, clearly recognizes this principle in the law, that the thing patented is the thing claimed, regardless of what the patentee might think he invented. So how can we reconcile this development of claims and the recognition of the primacy of claims with Robinson's theory that the patent protects the idea of means and his commitment to the independent existence of the invention? The answer is that for Robinson, the inventor's rights extended to all things or acts that embodied the same idea of means as the invention. The idea of means was the essence of the invention, and therefore the inventor's rights were coextensive with all things embodying the same idea of means. How was this to be achieved in the context of the peripheral claiming system? First of all, Robinson advocated a liberal reissue practice. That is, if the patentee had failed to claim all the embodiments to which he was entitled, he could go back and enlarge the scope of his claims. Second, as I've mentioned, the process of infringement of a claim is defined as including all equivalents that embody the same idea of means as embodied in the claim. So even though the patentee might be restricted to the claim, the infringement inquiry extends to all things that embody the same idea of means. Finally, Robinson advocated this complete protection to the idea of means by a liberal view of claim construction. In Robinson's view, one had to construe the claim, to interpret the claim, if possible, to correspond with the actual invention. As Robinson says, to apply such claims and descriptions to the invention as it really exists. And again, you can see Robinson's commitment to the real existence of the invention and the significance of the real physical thing of the invention, and the patent as recognition of that fact rather than a mere creation of positive law. Now, if this notion of idea of means as the essence of the invention was the cornerstone of Robinson's system, and if Robinson's work was the Bible of American patent law, we might expect that this notion of idea of means as the essence of invention occupy a central place in our current patent doctrine. That, however, is most decidedly not the case. Today, we generally deny that there is such a thing as essence of the invention. As the Supreme Court said in the Aero Manufacturing case, in the context of a combination patent, and most all patents are combination patents, there is no such thing as an essential element, gist, or heart of the invention. And courts have extended Arrow's rejection of the idea of essence to essentially all categories of inventions. Moreover, to some extent, we even deny the reality of the physical invention, as this quote from Judge Rich, one of the fathers of modern patent law, shows. Instead, the claim is synonymous with the invention. And when we teach patent law, the very first thing that we teach our students is that all questions of patent law, of infringement, of validity, and any other inquiry, are decided solely by reference to the properties that are recited by the claim. So if I could give you a caricature of modern patent law, the invention is the claim. Claims not only mark the boundary of the invention, but they are the invention. And moreover, in patent law, we only do three things. We compare the patent claim, or the features recited in the claim, to the prior art to decide questions of novelty or non-obviousness. We compare the features recited in the claim to the patentee's disclosure to decide questions of compliance with Section 112. And we compare the features recited in the claim to the accused device or process to decide infringement. Now, this, again, is a caricature. But it is true that in modern patent law, the claim merely recites a collection of properties that define the subject matter of the property. And no one feature recited by the claim is more important than any other feature recited by the claim, regardless of whether it is essential or novel to the invention. How did this development come to be? How did we depart from Robinson's conception? Well, in part, honestly, Robinson's theory of the idea of means was unworkable. His model that all ideas of means could be reduced to an object, a force, and a mode of application is difficult to apply to all inventions, and Robinson didn't give us any real practical examples of such application. So even if one was attracted to the notion of idea of means, Robinson's particular system for implementing it was untenable. Second, courts became less solicitous of inventors than Robinson was, and put paramount value on the public being able to ascertain the limits of the patentee's property. And so we placed paramount importance on the ability of claims to precisely define the boundaries of the invention. So, too, we moved away from Robinson's view of patent as a contract, an exchange between the government or society and the inventor, and moved instead to one of property. A contractual view lingered at some of the regional circuit courts in the 1970s, but was rejected by the Court of Customs and Patent Appeals, the Federal Circuit's predecessor. And in this view, the patent is not an instrument that we interpret in order to effectuate an exchange of obligations between the inventor and society, but as an instrument that defines the precise boundaries of the inventor's property. It's probably also true that larger philosophical and jurisprudential trends contributed to the abandonment of Robinson's ideas. Law embraced positivism almost entirely, and generally rejected the notion that formalism or formal theories could be a unifying principle of law. And moreover, it's likely that philosophy's general rejection of essentialism and the associated techniques of the scholastic method eventually permeated into law as well. However, I would argue that we have not been successful in banishing the essence of the invention from patent law. There are difficulties in a purely peripheral scheme, like the caricature that I've just described. First is the question of claim construction, which, if you follow patent law, know is one of the most vexing issues in patent litigation. If the invention has no independent existence outside of the claim, what is it that we are interpreting when we interpret claims? We're not interpreting claims as a representation of the actual invention, because there is no such thing as the actual invention. Nor can we invoke contractual models of interpretation, since patents are not contracts, they are grants of property. Rather, we're seeking to interpret a bundle of properties that have emerged from the interaction of an applicant and an examiner. But this model doesn't give us any guiding principle with which to guide the process of claim interpretation. Second, I think the pure peripheral model causes us difficulties in some of our doctrines of infringement. This may be the case in the doctrine of equivalence. Again, if you've studied patent law, you know we reject the notion that to be equivalent, an accused device must be equivalent to the claim as a whole. We insist that the accused device must contain equivalence to all of those features that are recited by the claim. And yet in this inquiry, we do not ascribe particular importance to any of the features recited in the claim that might be novel or essential. And the result, not only under the doctrine of equivalence, but other doctrines as well, as Mark Lemley has pointed out, is that the infringer may appropriate the critical or essential elements of the invention, so long as he makes substantial changes in some other property recited by the claim. And perhaps demanding, as in Robinson's time, that the alleged equivalent embody the inventor's idea of means would provide us with a better test between the rejected approach of claim as a whole and today's approach of element-by-element equivalence. Patent law also struggles with the problem of after-arising technology. How do we decide whether an inventor is entitled to reach technologies that fall within the literal boundaries of his claim but may have arisen much after the inventor made his invention? As an example, let me actually refer to the biotechnology case that Judge Shull described in his introduction, the Amgen versus Transkaryotic case. In that case, the claims in the patent were to the production of a synthetic human hormone, erythropoietin. Now, the patentee had cloned the gene encoding this human erythropoietin molecule and used standard expression systems in order to produce the synthetic hormone. More than a decade later, the accused infringer came along and developed a method of producing the synthetic hormone that did not employ the same technology that the patentee had used, the cloned EPO DNA. Now, in the case that Judge Shull and I worked on, the court considered the doctrines of claim construction, enablement, and written description, but none of those doctrines really provided a handle to address, if the question should have been addressed, whether the patentee should be able to assert rights over a later developed technology. For Robinson, this might have been an easy case. The accused infringer did not employ the same idea of means as the patentee, and therefore no infringement. Now, cases like Amgen might call for the application of what's known as the reverse doctrine of equivalence. The reverse doctrine of equivalence is an old doctrine which states that if an infringer has changed the fundamental principle of the invention, he will not infringe even though he may fall within the literal boundaries of the claim. The reverse doctrine of equivalence is a favorite tool for scholars to balance the innovations and costs, the benefits and costs of the patent system, and to balance innovation between earlier and later innovators. But modern courts have been extremely reluctant to apply it. This is the result, I think, of the purely peripheral system. If the claim is the invention, it is almost syntactically insensible to speak of something falling within the claim but differing in principle from the invention. The reverse doctrine of equivalence, when you think about it, is nothing more than the concept of the idea of means as the essence of the invention. And if we're willing to define the principle of the invention as Robinson's idea of means, the reverse doctrine of equivalence may become much more straightforward to apply. Another issue that modern patent law struggles with is the nature of the disclosure doctrines. What must the inventor disclose in order to be entitled to a claim of particular scope? Now, formally, as I've argued in my work, modern peripheral claims define a nearly infinite genus of objects that merely share some of the properties that are recited by the claims. How can we decide whether the inventor has disclosed enough information to give him rights to this collection of objects? Well, whatever the answer may be, it seems to have relatively little to do with the question of what did the inventor actually describe or invent. And yet, despite its nominal rejection of the essence of the invention, I think the Federal Circuit has found it necessary to retain these concepts in its disclosure jurisprudence. For example, in the doctrine of enablement, the Court has held relatively recently that the patentee must specifically enable the novel features of the invention rather than rely on the prior art to provide this disclosure. This is despite the lack of significance of the novel features of the invention in a pure peripheral system. Moreover, in the area of written description, the court has found it necessary to retain the doctrine that the disclosure describe subject matter, not simply that the disclosure enable one of skill in the art to practice the claimed subject matter. The written description doctrine in this formulation represents a tie between what the patentee claims and what the patentee actually invented. And I think the court's retention of this doctrine recognizes a necessary commitment to the existence of the invention as something that independently exists apart from the claim. I'll conclude by describing some not implicit but explicit rejections of this anti-essentialism in modern patent law. One recent example is the doctrine of patent exhaustion and the Supreme Court's case in Quanta versus LG Electronics. Now, the doctrine of exhaustion holds that once a patentee makes an authorized sale of something that embodies his invention, he loses further rights to control the disposition of the article. And in the Quanta case, the patentee argued that what he sold, or what he authorized to be sold, did not actually embody the claimed invention, because it was a computer chip, and you had to combine that computer chip with other things before you could practice the claimed invention. So what was claimed was not embodied in what the patentee sold. And this reasoning was persuasive to the Federal Circuit, but not to the Supreme Court. And Justice Thomas's opinion in Quanta clearly rejects the anti-essentialist position that the patentee argued. What Justice Thomas held, in effect, in Quanta was that what the patentee sold embodied the essence of the invention. And Justice Thomas used the language of essence explicitly and rejected the notion, extending back to Arrow in the 1960s, that the notion of an essence or gist of a claim should be banished from patent law. This trend has also been apparent in the Supreme Court's treatment of patentable subject matter in its recent Bilski case. Now, the Supreme Court has struggled for decades to explain when an unpatentable abstract idea, natural phenomenon, or law of nature is embedded in a claim, how do we decide if that claim itself is unpatentable subject matter? Robinson's answer, of course, would be to ask what was the idea of means embedded in the invention. Now, the Supreme Court in Bilski was deciding the patentability of a so-called business method patent. The court examined Bilski's claims and concluded that, at bottom, Bilski was doing nothing more than claiming the concept of hedging. In so doing, the court paid relatively little attention to the specific limitations of Bilski's claims. What the court concluded was that Bilski was claiming, in essence, an abstract idea, and that was sufficient reason to invalidate his claims. Finally, let me mention the recent Myriad Genetics case in which the Southern District of New York held that human genes are natural products and thus patentable subject matter under Section 101, a case that is currently on appeal before the Federal Circuit and watched with great interest by all observers of the patent system. Now, patent law has long granted patents on isolated or synthetic versions of natural products on the theory that that isolated or synthetic versions of molecules, including DNA, are not things that are found in nature. However, the Southern District of New York rejected that reasoning, and its reasoning in concluding that human genes were not patentable subject matter was simple. Human genes are natural products. In the court's view, the essence of human genes lies in their informational content, and that essence, that informational content, remains intact when we produce isolated or synthetic forms of human genes. So therefore, in the Southern District's view, isolated or synthetic human genes retain the same essence as natural genes and should therefore be regarded as natural products. Now, whether one agrees with these decisions or not, I think they all herald a rejection of the notion that questions of patent law can be answered solely by reference to the precise limitations spelled out by the claim. So let me conclude. I am certainly not the only one to point out these cracks in the foundation of our current system of patent law. And a number of scholars are beginning to challenge the current paradigm of a purely peripheral system, arguing that it renders patent law unable to ask some of the basic questions about entitlement that a rational patent system ought to be able to answer. Some suggest that we ought to return to a central claiming system, like that which prevailed in the 19th century. Some suggest that we ought to focus more exclusively on the novel points of novelty of the invention. And some suggest that we need to rescue the invention from the cult of the claim. Let me suggest what all these scholars are circling around is the notion of essence of the invention. And I would set the challenge for modern patent law theorists as this: to reconstruct Robinson's theory of the essence of the invention, the idea of means, in a form that's applicable to the demands of the modern patent system. And we may find that if we reconstruct his theory of the essence of the invention, we will also recover the essence of patent law as well. So thank you very much for your attention. So I'll be happy if people have questions or comments or want to relay anecdotes about Robinson's life. Yes?
I have a question about the patent that you mentioned that Robinson's brother.
Yes.
Do you know if a product was made from it or if there was any patent litigation involved?
I wasn't able to find any reference to that patent. It was for some sort of an explosive. Robinson's brother was also, might have also been a doctor, but he certainly experimented the chemical arts. I have seen reference to it in one or two texts on explosives, but I've not found any evidence that the patent was ever asserted after Robinson bought it.
You said that after he wrote his treatise, Robinson had never read about patent law yet, so I'm wondering what scholars did at this time.
I think Robinson's life focused on administration largely after that. He came, of course, he began working with Bishop Keene in 1891 to establish the School of Social Sciences here, and came here in 1895. And I think administrative concerns and the struggles of establishing and maintaining the university occupied most of his time. His wife also died at about that time. He remarried, I think, around 1893 and had 2 or 3 more children. He did... 1891. Yes. 1891, and 4 children, one of whom died. He did produce one more work, Elements of American Jurisprudence, which was a general textbook on American jurisprudence. But I have not found any reference to why he did not return to patent law. The only other work on patent law that he produced was an article that he wrote for the Columbian Exposition in Chicago in 1893 about patent law that was later published in the Yale Law Journal. So he was definitely recognized in his lifetime as an authority on patent law. But whether because of the demands of family life or of administration, he did not return to patent law. Yes, Judge.
Early in your lecture, you had that very interesting chart about the number of times that Robinson was cited during a certain period in various decisions, and 2 other treatises were cited. Do you see in current jurisprudence, and you don't have to confine it to patent law, the extent, an increase or decrease in the use of academic articles or law review articles or treatises in decisions as opposed to cases being decided?
I think it's much less frequent. We see relatively few citations to treatises at this point, and then generally only of historical interest. Other people have written about the question of academic scholarship, made some claims that the Federal Circuit tends to cite law review articles less frequently than other circuits. I don't know if that's the case or not. I think in our era, the treatise is simply less important because we have other means of recovering and systematizing the law. So we don't rely on treatises to the same extent. So that may be one reason why we certainly see much less citation to treatises. As to scholarship, frankly, most academics are not as interested in practical questions that might be relevant to a particular case or not. Of course, one of Robinson's virtues is that he had a long career as a practicing lawyer for over 20 years before he sat down to write patent law. And so he was very keenly attuned to the actual realities of the patent system.
Was he a general practitioner before he wrote his treatise?
He was. I can find no indication that he ever handled a patent case in his career. He was entirely a general practitioner. Also served on the tax board of New Haven and held one or two other judge of the municipal court there as well. But no apparent connection to patent law other than the ones that I've mentioned. Yes?
There may be one other connection to medieval scholasticism. In your talk, if I understood you correctly, he makes a statement that patents should be interpreted broadly.
Yes, the principle of making the interpretation of the claim correspond to the true invention.
Well, there was a very common legal maxim at the time of St. Thomas, and I have no idea whether it's in St. Thomas, but St. Thomas did a lot of law and known about it. And the maxim was privileges. He thought of patents, at least earlier on, he thought of them as privileges. Privileges must be interpreted broadly.
That's very interesting because in the first 100 pages or so of Robinson's treatise, the part that most modern readers skip over, is a consideration of what is the true nature of a patent. He spends all that time discussing the question of whether patents are a monopoly or not, and therefore should we generally construe them narrowly or broadly. And he concludes that patents are a monopoly in derogation of the common law. Nonetheless, he views them as a necessary monopoly and one that's entirely appropriate for the state to recognize. And what I didn't mention here is that though Robinson said we should be broad when construing, essentially we should be generous in construing society's obligations to the patentee, what we should protect in the letter's patent. But he took the other point of view with the patentee's obligations to society. He said we should be liberal to society when we're asking about the patentee's disclosure. So he would put his thumb on the scale of society when assessing the patentee's obligations to society, but the thumb on the scale for the patentee when looking at society's obligations to the patentee. But I'll definitely try to track down that notion of privilege and see if that's something embodied in Robinson's thought.
My grandmother told me years ago, many years ago, I'm not sure that I remember totally correctly, but she said that the judge converted to Catholicism because he wanted to marry a second wife who was a Catholic. No. But what you're saying is that he converted way before.
Yeah.
He converted a long time ago.
Whoops. Yes.
The story that came from our the second generation was that he was teaching religious class where he was in Pennsylvania, and some child who was Catholic came and he borrowed the boy's catechism, and that was the beginning. Isn't that right? Well, yeah, a little bit, but also his first child died, and that really has shown his family did that, and that's highly different.
Any other comments or questions? Thank you.
All right. Thank you.
We would like to thank Professor Lefston for his wonderful lecture and thank Judge Shaw for joining us and for introducing Professor Lefston. And we'd like to thank all of you for coming. A special thanks to the many members of Dean Robinson's family who are here today, many of whom traveled long distances to join us. We really appreciate your interest in our lecture series and your support, and we would like to invite everyone to join us outside in the atrium for a reception. Yes? Yes, please. Everyone stand up. My understanding is there are people who flew in from Texas and Florida and people from Connecticut. So, yes, so thank you. Thank you for being here.